Welcome to Friday Friends, RI Elder Info's weekly look at the organizations and individuals providing resources for Rhode Island seniors, caregivers, and professionals.
Good morning, everybody. Happy Friday. It is 9 o'clock on Friday, and you are watching me, Deb Burton, host of Friday Friends, where every Friday I bring you information and resources that you or someone you know needs to know about. So please make sure you hit the bells, the whistles, the icons, the subscribe, all those things that say, hey, check this out. Because today we're having a conversation about something that I myself get a little mixed up on. So if I'm getting mixed up on it, I know I'm not the only one. So really important that we get the word out today. Now, as you all know, RI Elder Info is a 501c3 nonprofit, and we could not do this without the support of our sponsors and donors. And we are so grateful to United Healthcare and especially our Friday Friends sponsor, McCarthy Law. Here's a message from McCarthy Law.
Here at McCarthy Law, we practice in the areas of estate planning, long-term care planning, elder care law, and residential real estate. Our focus is really on providing peace of mind to our clients.
If you're interested in scheduling a consultation with our office, you can feel free to reach out to us at 401-541-5540. You can also reach out via website at www.mccarthylawri.com. You also should check out our social media, both on Facebook, Instagram, and LinkedIn for some helpful tips and tricks.
Welcome, Whitney. How are you today?
Well, how are you? Thanks for having me.
Very good. For those folks who may not recognize you from when I've had you on the show before, please tell everybody who you are and where you're from.
Sure. My name is Whitney Anderson. I'm an estate planning attorney at McCarthy Law in East Greenwich, Rhode Island.
Awesome. Awesome. I'm really glad that you're able to join us today because I get asked questions about trusts, irrevocable trusts, all these different things. And I can't provide any kind of legal advice or anything like that. And I tell that to everybody all the time. But I don't really understand myself what a trust is and an irrevocable trust versus a regular trust. And I'm so glad that you're able to come on today and help us understand those things. Please explain.
Sure. So what is a trust? It's a legal arrangement. It allows one person, that person would be called the grantor, or sometimes referred to as the settlor, to give another person or sometimes an institution like a bank, and that would be, they would be called the trustees. It allows the grantor to provide the trustees the authority to manage assets for the benefit of someone else. That is referred to as the beneficiary. So we typically kind of use an analogy, right? The analogy of like a bucket or, a container. So if you think of a trust like that, it's where you can safely place your assets. Things like your home is a big one. Bank accounts, investment accounts, typically, the home and investment accounts. And then, you place that into the trust, that bucket. And you're then able to write essentially what are instructions, which is actually the trust agreement, is like instructions for how those assets should be distributed to your beneficiary upon your passing. Okay. Then there's also, guidelines in terms of, who has the control of those assets during your lifetime.
Okay. So what's the difference between a trust and then an irrevocable trust?
Mm-hmm. So an irrevocable trust is a type of trust. There's two types of trusts, revocable and irrevocable. So With a revocable trust, as the name suggests, the grantor, the person who is creating the trust, has the ability to revoke the trust, so get rid of the trust if they want. But similar to a will, right, where you can update a will over time during your lifetime, as long as you have the capacity to do so, you can amend the terms of your trust over time. It is a really great estate planning tool for probate avoidance. Primarily, any type of trust is going to provide you probate avoidance if funded correctly. Revocable trusts are really great for really anyone in their life that is not concerned about say the nursing home and Medicaid asset protection. It can really streamline your estate plan. You can, in a revocable trust, you can be both the grantor, so the person setting up the trust, as well as the trustee, the person who is in the driver's seat that can manage and control the trust. So you get to wear both hats. You enter into that legal arrangement with yourself during your lifetime, if it's a revocable trust. And then you would, within the trust, designate successor trustees who, similar, again, I'm just going to kind of use a will because I think people are just more familiar with that. Even it's just more prevalent even in like movies and that type of thing. Yep. Everyone kind of knows what an executor is to a certain, or has like a working knowledge, right? So your successor trustee would be very similar in terms of like an executor of your will. Okay. Someone who's in charge of carrying out the trust agreement, those written instructions that are part of your trust. So what does that look like? Making sure that those distributions are being made for the benefit of whoever your beneficiaries are, right? So those beneficiaries are not inheriting from your trust until after you've passed, according to whatever the terms are.
How would that be different than just keeping everything in my own name and having it go through a will? Why would I do a revocable trust? What are the benefits of that?
Yeah, so great question. I think I'm noticing a lot that there is a misconception that if I have a will, I'm all set and I don't need probate. Well, if you have a will is instructions only for if you are in probate. It only speaks to and distributes assets that are subject to the probate court process. So how do we wind up in probate court? Just a little refresher, and I'm sure it's been talked about before, but when you die, any assets that are in your name, if that asset does not have either a joint living owner or a living named beneficiary, there's nothing that says who it's supposed to go to. No joint owner, no living beneficiary. It's subject to probate court judicial oversight so that they can figure out who's going to get it. That's also where they figure out who's going to be in charge of distributing it. If you have a will, that's where it would come into play. So if you have someone named on, you just have, say, one child named on your bank account because as like I say, a joint owner, because they kind of are helping you out. But really, you'd like everything to be divided equally amongst all your children. And that's what it says in your will. That bank account is going to go directly to that one child. It's not going to be divided up equally amongst your children because there was one of those two things, a joint living owner or a living beneficiary. So we can name an owner or a beneficiary on pretty much everything. You can do that on bank accounts. A lot of people don't know that, but you can name beneficiaries on bank accounts. Of course, retirement accounts, investment accounts, that type of thing. For a house, typically what we see is, if you are married, you own that jointly with your spouse. When the surviving spouse passes, that is when the home is subject to probate court, and we have adult children that are then subject to that process. That is why for a revocable trust, you're going to get that probate avoidance piece, and can kind of streamline avoiding, this very kind of lengthy process. It's a 6-month minimum waiting period before you have access to any assets in probate court. That is where, during that time, any creditors the decedent has can file claims against the estate. If there's nothing in probate court, then oh well, too bad, so sad for any credit card companies out there, etc. Your family is under no obligation to pay your debts if you've passed out of their own pocket. So a trust can avoid all of that. And there's also protections for beneficiaries. If someone had, a substance abuse issue, maybe, a child, you want to leave them something, but you're worried they're not going to manage their funds properly. That trustee, that person who's in charge of distributing your assets, you can put instructions in there about kind of oversight, in terms of kind of handling those funds, giving it for certain, specific needs of that child for their benefit, but maybe not just kind of, unfettered access. Minor children, it's also very helpful. So those are reasons why someone would go with a trust versus a will in general. I know you had asked originally about what is an irrevocable trust. So you'd asked what's a trust versus irrevocable trust. So there's the revocable trust I just spoke about. Then there's the irrevocable trust. There's all types of irrevocable trust. The one that I'll speak about today and that we do most common in our practice is a Medicaid asset protection trust. So any assets that you put into this particular trust, as long as they've been in there for at least 5 years prior to an application for Medicaid, they are not considered an available asset to pay for long-term care. So that is why those are very popular for, when people are perhaps facing, health concerns, and want to be proactive about that. Yep.
And so, so you've got the regular trust, and that'll help you avoid probate and make sure that there are some, you can structure it so that there are some guardrails on how the beneficiaries of the trust or potential recipients of the assets of the trust are allowed to take those things. So, the kids aren't going to suddenly inherit your money and say, I'm going to the casino.
Mm-hmm.
You can say like, all right, this can be used for your education. This can be used towards the, your down payment for your house, those kinds of things with a revocable trust. And it solves some of the challenges with having to probate a will, which can take up to 6 months. And that's when the creditors can come. Those outstanding bills would need to be rectified in a will situation before any inheritances got allocated. Now, with an irrevocable trust, for that being related to Medicaid, and I just want to remind everybody, Medicare does not cover long-term care. So if you do need long-term care, you have to think about how is that getting paid, and you can pay for it out of pocket. Cash is always king, but people sometimes want to protect their assets, and that's where this irrevocable trust comes from. So if I set up an irrevocable trust with the expectation that, I'm going to have fabulous health for the next 5 years, but in reality, I, God forbid, have a stroke and now I need care at home. And my only way to do that might be like a reverse mortgage or something like that. Is that still possible if a house is in an irrevocable trust, or do I no longer own it to be able to do that?
So in terms of getting a reverse mortgage, I'm not sure if you're going to be able to do that in an irrevocable trust. I know that, for instance, with a home equity line of credit, you get that no problem. With a revocable trust, you're going to have it's really not it's going to be very difficult, if not possible, to get that if it was in an irrevocable trust. The reason for that being is kind of that access and control, right? So the trustee is the one that has the authority to manage assets that are in the trust. If your home is in the trust, it's an asset of the trust. For an irrevocable trust, you are not the trustees of your irrevocable trust. You are still the grantors, the ones that are setting it up. So you still get to outline the terms, but you cannot be the in charge of managing whatever assets are in your trust. That is why you are allowed certain protections, right? If you are telling Medicaid that this is not an asset that's available to you to pay for your care, then this cannot be an asset that is available to you.
Got it. Okay, so it's kind of like with the revocable trust, you can put your items in the revocable trust.
Mm-hmm.
And if you do need long-term care and you need to pay for it, the Medicaid says, well, if you put it in, you can take it out.
Mm-hmm.
But with an irrevocable trust, you put it in, assuming 5 years goes by, because it's irrevocable, you can't take it out.
Mm-hmm.
Somewhere down the line, would I be correct that there would be a trustee of the trust, but not yourself, who can do something with the assets in that irrevocable trust?
The trustee can manage those assets, yes. So during your lifetime, say you put your home into the trust. Mm-hmm. It's very popular to put real estate into an irrevocable trust because you kind of feel that restriction the least. What I mean by that is you still are considered a life tenant of your real estate.
Okay.
Your trustees are not allowed to kick you out of your home. They are not allowed to charge you rent. So that feels very similar.
Yep.
You continue to pay your property taxes as you normally do. You're going to see it come in the name of the trust, but you are still responsible for paying those taxes. Your trust, if you wanted to sell your home because you're not the trustee, your trustees would have to sell that property. Now, the tricky thing with that is, say they're selling your home and you're going to rent for whatever reason. So there's going to be, a substantial amount of proceeds. Those proceeds don't belong to you as an individual. They belong to your trust. Those proceeds would need to go into an account in the name of your irrevocable trust. You do not have access to the proceeds from your that are in that irrevocable trust account, because again, you are saying, I don't have control over these assets. Any assets you're putting into an irrevocable trust, we tell our clients to think of it as like you're just earmarking it for the next generation during your lifetime.
Okay.
You can, what's more common is your kids could purchase a substitute property for you. And that would still be within like running that 5-year clock. That would still count and still be protected, the substitute property.
Yep. Okay. Now, if it's a situation where if your house is in the irrevocable trust and that house gets sold, it's the property of the trust, so the proceeds of the sale still belong to the trust. Does the trustee, say kids, have the ability to, assuming 5 years has gone by for clarity, do the kids have the ability to utilize the proceeds of the trust if they choose to pay for, say, a nicer nursing home, or choose to pay for 24/7 home care for me? Can they do that with the proceeds of the trust, where I am receiving the benefits of the trust even though I don't own the trust?
That's a good question. I would probably defer to one of the elder law attorneys, but if I were to give you my most educated guess, I would say that would be risky. So essentially the trustee How would you get money out of the trust? There needs to be a beneficiary, right? The trustee isn't entitled to the money themselves.
Oh, okay. Yep.
You can name a lifetime beneficiary, so someone who's
Yep.
benefiting from the trust during your lifetime,
Yep.
because you yourself are not entitled to access to income or principal. So that lifetime beneficiary is entitled to funds, but those funds are supposed to be for the benefit of that lifetime beneficiary, which is not
Got it.
you.
And it would probably look a
They're
lot
on the
like
side of
that
caution.
application, that same thing. Like if you're using revocable, well, if you put the money in and you can take the money out, then Medicaid's going to say, then take the money out. And if you have an irrevocable and there's a way for somebody else to take it out to benefit you, Medicaid would say, take the money out. So it sounds like the best practice when you're looking at how you want your family members to inherit anything when you pass away in the easiest, simplest form. And or if you're expecting that you would need long-term care and want to protect your resources to be able to qualify for Medicaid, it sounds like because there's so many variables, it's really important for folks to talk to yourself or another elder law attorney. So that way you're not trying to like do the hokey pokey with your assets. You put it in, you take it out and turn all around and find out, ooh, I get just hit with a bill.
I totally agree. Yes, absolutely. I like to err on the side of caution, as does, really everyone at my firm. So you definitely would want to check in prior to, using that lifetime beneficiary, role to take out money to try to help mom or dad. It's because you don't want to wind up causing problems for them.
Yeah. Totally.
They can't seem they have access to something that they shouldn't.
Yeah, absolutely. This has been really helpful to help me understand. I'm sure our viewers are really appreciating it. So thank you so much for coming on today. This is one of those things that just struggle to wrap my head around.
Thank you for having me. And thanks you. I feel like I talked like so much. So sorry.
No, that's perfect. I appreciate it. Thank you. Because it's one of those subjects with so many nuances, and as a layperson, not an expert in law at all, I feel like it's so easy to get tripped up and stumble. And that's why, like, I'm grateful that you took the time today to explain this. This is so helpful.
Absolutely. Thank you. Thanks so much. It's always nice coming on.
Yes, thank you. I'll see you again.
Okay. Take care. Bye-bye.
Everybody, trusts are one of those things that, like I said, it's hard for me to conceive. And whatever you do, you don't want to do the hokey pokey with your finances and your assets. Make sure that you're speaking with an expert in relation to setting up trusts. If you have a trust already set up, and maybe you did it like decades ago, pull it out, dust it off, make sure that it is still accurate. Maybe take a look at whether or not it needs to be updated. Our friends over at McCarthy Law will be more than happy to help you with that. And you want to make sure that everything is still accurate. Is it still, your child and their spouse? Is it the same spouse? Is it the grandchild, or are there now grandchildren, or maybe even great-grandchildren? Important that all of these things be as up to date as you can make them, and that they are executing what you want done currently. Maybe what you wanted done 5, 10, 20 years ago was different than today. But it's always better to plan ahead. An ounce of prevention is a heck of a lot cheaper than a pound of cure. So, my friends, I am so glad that you joined us today. I look forward to seeing you all again next week. In the meantime, be well and be kind.